afternoon, everyone, and welcome to the 2026 Emroch Lecture. Each year, we bring exceptional scholars and speakers to the law school for the benefit of students, faculty, and the local community. And we're able to do this thanks to the generosity of the family of Richmond Law alumnus Emmanuel Emroch. Emmanuel Emroch was a 1931 graduate of the law school and had a very distinguished career as a trial lawyer. But Mr. Emroch was much more than a terrific lawyer. He was committed to the principle of equality and founder of the Richmond chapter of the National Conference of Christians and Jews, and spearheaded that group's anti-discrimination efforts. In 1974, he was honored by the NCCJ with the organization's Humanitarian Award. Given Mr. Emroch's commitment to justice and equality, our Emroch speaker this year, Dylan Penningroth, is particularly appropriate. I'm going to turn things over to Professor Harbach to introduce our speaker.
Good afternoon, everyone. It is my sincere pleasure to welcome Professor Dylan Penningroth to deliver today's Emroch Lecture. Professor Penningroth is Professor of Law and the Alexander F. and May T. Morrison Professor of American History and Citizenship at the University of California, Berkeley. Professor Penningroth teaches and writes on legal history, race and law, and African American history. His latest book, Before the Movement, The Hidden History of Civil Rights, won 11 book prizes and was shortlisted for 4 more. His first book, The Claims of Kinfolk, African American Property and Community in the 19th Century South, won the Avery Craven Prize from the Organization of American Historians. Professor Penningroth has held fellowships from the National Endowment for the Humanities, the National Science Foundation, the Stanford Humanities Center, and the MacArthur Foundation. Before joining UC Berkeley in 2015, Professor Penningroth served on the faculty of the History Department at the University of Virginia, at Northwestern University, and was also a research professor at the American Bar Foundation. He earned his BA from Yale University and his PhD at Johns Hopkins University. We are delighted to welcome Professor Penningroth back to Richmond, where he has done significant archival work, and we're especially thrilled to welcome him for the first time to Richmond Law. The title of today's lecture is Hidden Histories of Black Civil Rights. Please join me in welcoming Professor Dylan Penningroth.
Really, thank you so much for that generous introduction. It's really an honor to be invited to deliver the Emmanuel Emroch Lecture. Thanks to all of you for being here today, spending your lunch hour with me talking about legal history. So let me start with a story about an American lawyer you're probably very familiar with. So you all know who this is. And the story I'm going to tell you does not take place when this picture is taken. It happens in just after Christmas in 1973. And of course, Thurgood Marshall is the first African-American Supreme Court justice, and he sits down for an interview with a white journalist named Richard Kluger. And Kluger, at this point, wants to talk with Marshall about Marshall's most famous case, Brown versus Board of Education. It's been 20 years by that point, nearly, since Marshall had argued that case as head of the NAACP-LDF's Legal Defense Fund legal team. And ever since the day that case decision was handed down, white critics from all over the political spectrum had accused the court of misbehaving, essentially behaving like politicians in robes, imposing their personal values unrestrained by statute or precedent. And many critics singled out one footnote, the famous footnote 11, which cited psychology research purporting to show that segregated schools damaged black children's self-image, that these laws fastened onto them a badge of inferiority that could not be removed simply by making the schools equal. So Kluger asked Marshall the question that was on everybody's mind. How did the lawyers for the LDF decide that they were going to rely on these doll tests? And Marshall did not hesitate, and I'll quote, "I said that we had to try this case just like any other case with damages. Just as if your car ran over me, you'd have to pay up." And so I'm sitting in the Yale University archives, and I'm reading Kluger's handwritten notes, and I'm thinking to myself, okay, ask a follow-up question, ask him what he means by that, but he moved right on. And when his book came out a couple of years later, it was titled Simple Justice. And it was about the brave black folk who waged, and I'll quote again here, Black America's struggle for equality. But I kept wondering, why was the hero of this sacred struggle for equality talking like a personal injury lawyer? And now, years later, I think I understand. It's because Marshall wasn't just talking to Kluger, he was talking to black people in Topeka and all over the United States, and black people, Marshall knew perfectly well what a personal injury lawsuit was. Now that statement might seem a little surprising today, and I think that's because we've lost touch with the world that Marshall lived in and worked in. Kluger's book, Simple Justice, was an early entry in what I think has since become what you might call the grand narrative of African American history. That is, an unfinished freedom struggle, a journey from second-class citizenship to full citizenship, from black fear in the face of white lawlessness to black people defiantly asserting their rights under the law. So according to this story, which I was trained in, once upon a time the legal system was dominated by racist local and state officials, and these officials refused to recognize not only black people's civil rights and political rights, but their basic dignity, and sometimes even their lives. So on this account, law was an unknowable, often deadly force. It was something that if you were black, you tried to avoid at all costs. And then in the 1940s, the story goes, a few brave lawyers ventured south, and they were bent on changing the law. They wanted to force the federal government to recognize, they wanted to force the federal government to force those state and local officials to recognize black people as full and equal members of American society. And soon a mass movement for racial justice joined them. And this, I think, is, in a sense, the master narrative, not just of civil rights, but of African American history. And it's not wrong. At some level, it's not wrong. Police are still killing people of color. And now, political leaders are in fact openly attacking what were thought to have been bedrock anti-discrimination laws, like the Equal Employment Opportunity Act of 1965. And so I just want to start by saying that movement-centered scholarship, I believe, is as urgent and necessary today as it was in the 1960s. But I also think that conceiving of black history in this way, as a freedom struggle, has cost us some things. For one thing, it makes black history seem as if it was synonymous with race relations, as if black lives only matter when there's a white person somewhere in the picture. Second, it tends to lay a moral burden on the field of African American history. It urges us to judge our ancestors according to how well they advanced the freedom struggle. It segregates the law curriculum. It slots race into public law, by and large, and constitutional law, and it makes private law seem as if it were white in some way. Most of all, I would argue, it has tended to shrink our vision of black life down to the few areas where federal law and social movements made some kind of difference. So in the freedom struggle story, black people are portrayed as untutored in law and alienated from the legal system. But if that's so, then why is it that when a mass movement for racial justice finally took hold in the 1950s, why is it that so many black people put their faith in law at all? I think that in different ways and for different reasons, both legal scholars and U.S. historians have left black people disconnected from our own legal common sense. That is, the way that we actually think about and use and talk about law. And that, in turn, has made it harder to see black people as people in full. Oh, thank you. Appreciate it. So today I want to propose to you that long before the Brown case, long before the movement, black people routinely exercised their civil rights. In fact, activists and civil rights lawyers often counted on the fact that ordinary black people had civil rights. But these weren't the rights that we think of as civil rights today. They weren't about protection from discrimination or subordination on the basis of race or sex or other protected categories. Instead, I'm talking about what Senator Jacob Howard of Michigan, who was one of the framers of the 14th Amendment, what he called the ordinary rights of a free man. The basic rights of property, contract, the right to sue and be sued. And these are, of course, the rights that Congress wrote into America's first national civil rights law, the Civil Rights Act of 1866. So, when my great-great-aunt Annie Holcomb paid the burial insurance policy on my mother, in case my mother died, needed money for the burial, when my Nana paid this insurance policy each week on her doorstep, she was doing civil rights. When she and her husband, Thomas Holcomb, sold land to Midway Baptist Church in Virginia, where they grew up, every time, in other words, they did something that a court could protect, they were doing civil rights. They were making freedom mean something more than the negation of slavery. Civil rights, in other words, were rights of everyday use. But by 1973, when Marshall sat down with Kluger, the meaning of civil rights had changed. Now it meant the right not to be discriminated against, a special, set-aside body of law. So let's back up and let's see if my throat can hold up. So those of you who have read work in 19th century U.S. history will know that in the 19th century, white Americans tended to classify rights into three baskets. So there are political rights, like the right to vote, maybe the right to serve on juries. There are social rights, which, you know, my friend Kate Mazer once described to me as the rights that white people don't want black people to have. So it's this kind of flexible catch-all category that doesn't fall into political or civil. And then, of course, there's civil rights. It was clear to me when I began this project that political rights and social rights were, at the very least, highly contested and at the most, perhaps off limits to black people. Traditionally, U.S. historians have focused on political and social rights. I decided to focus on the third category because I guess that's kind of the type of person I am. And so I started with a very simple question. Did black people go to court? Right away, I ran into a fairly significant problem, which is that legal documents from the 19th century typically do not identify people by race, not even in local county courthouses in Mississippi. So this is kind of a surprise to me. And, you know, I'm thinking even the water fountains in these years are segregated. So there are some big analytical issues, there's some conceptual issues that I'd love to discuss. But here, what I want to talk about is the immediate practical issue. As I'm beginning this project, I want to write about African Americans in court, and I can't tell who's black. So to get around it, I would hop in my car. I would typically rent from whatever agency would give me the cheapest car, and they always gave me a Malibu no matter what I requested. It's always a Malibu. I remember it because I'm tall and the headrest kind of pushes me forward. And so I would spend a week or two at a time driving around and visiting county courthouses. So I'd show up at the office of the circuit clerk, and then I would ask, can I go in the back? 9 times out of 10, they said, fine, have at it. We're busy writing traffic tickets or processing title searches. Go on back there, knock yourself out. And so in those back rooms, I would pull down docket books, those big, heavy, leather-bound volumes, And I would choose them at 10-year intervals, so 1872, 82, 92, and so forth through 1962. And I would copy down the names of a subset of the cases on for that year. And so then I took those names back to my home in Evanston, and I gave them to my research assistants to look up on Ancestry.com. So we're talking about the one where you type it in and not the one where you swab to find out who your ancestor was. So once I had a list of cases that I knew involved African Americans, I went back to the courthouse and I read some of them. So you can probably guess this is not a foolproof method. Sometimes it was kind of gnarly, like, digging into these and I'm happy to talk about any of these courthouses, including that particular one. But by the end, we started to see a picture of when and where and why black people used the courts. So I started by asking, did they go to court? Yes, they did. By the end, we looked up more than 14,000 cases, and of those, we identified more than 1,500 that involved black people. These cases came from 4 states in the District of Columbia: Virginia, Mississippi, North Carolina, DC, Illinois, and New Jersey. So, race ducks in and out of Westlaw. If you do a Westlaw search and you try to use some keyword, you will turn up some cases involving black people, but there are an awful lot of them that you won't see. It's pretty much invisible in the dockets of county courthouses. This is how we made it visible. So what did black people do in their courthouses? Well, they did all kinds of things. They went there for a lot of the same reasons that white people did. They went there for divorce. That was probably the most numerous of the cases. But they also went there for insurance payouts. They sued over railroad accidents, unpaid rent, personal property, really almost anything you can think of. They also used private law in more routine ways, non-adversarial. So they sold easements on their land. They made wills. They sorted out home building contracts and landlord-tenant disputes. And of course, they bought and sold and gifted land like my relatives did. So by now you might be asking yourself, why would white Southerners who are dedicated to white supremacy, why would they let black people exercise their civil rights in the first place? There are a couple of answers that I think are not accurate. I don't think that they did this out of a sense of fairness. I also don't think that they did this out of a sense of paternalist obligation. And I also don't think that it was because, in some way, formal legal rules somehow trumped white racism. I think that the reason white people recognize black people's rights is because life's ordinary business could not go on if whites could not make contracts and convey property to black people. African Americans' property and contracts had legal meaning. That is, in a very real sense, but a very limited sense, black lives mattered to whites. White people who sought to murder, intimidate, or cheat black people out of their property, they could do that, and they sometimes did do that. But then they had to contend with the interests of other white people, as defined by particular legal rules, rules that were broadly understood as part of the common sense of law. Now, the overwhelming majority of cases involving black people were between black people, and this, I think, is another significant reason why whites let black people go to court. Only 8% of the cases in the Jim Crow slice of my sample crossed the color line. Now, obviously, white supremacy produced this skewed proportion. And yet, I think it's also important to recognize that even during these years when white officials are doing their very best to withhold education from African Americans, farmers took pride in what this Nate Shaw, what he called goat sense. And I sort of think of this as being the rough and ready legal knowledge that any adult is supposed to have. So for example, Shaw knew that each party to a joint promissory note is liable for the other's debt. He knew that a husband's mortgage, if a husband signed a mortgage, that mortgage did not cover household goods unless his wife also signed it. And he knew that a renter at the end of his lease had the right and the privilege to take anything that ain't tied down. Now, I looked up the relevant Alabama statutes, and I found that each one of these statements actually tracks fairly neatly with the extant law of the time. And I would argue that farmers like Nate Shaw, they learned this goat sense, they refined it through their daily experience, their daily conduct, their use of law, their exercise of civil rights. But they also discussed it in churches, in schools, and in black-owned newspapers. This is the official organ of the African Methodist Episcopal Church. And so what I'm saying is that for people like Shaw, who are steeped in the everyday of private law, it actually made a certain kind of sense to say that Brown versus Board of Education was just like any other case with damages. Now, one implication of what I've said so far is that African Americans cared very deeply about law and order. Now, I'm of course not talking about the law and order that some politicians have used over the years to justify anti-black and anti-immigrant constitutional violations. I'm talking about the law and order that led hundreds, if not thousands, of ordinary African Americans to file civil suits in county courthouses in the century after slavery's end. After all, what they suffered was not just over-policing, it was also under-policing. How to get the law to redress the wrongs that are being done to you. For African Americans, property and contract were civil rights. And, moreover, they hammered out their relationships with one another and with white people, not in fighting against law, not in defiance of law, but through law. Black people's long engagement with the rights of everyday use had some big implications, I think, and I'll just mention a couple. First, it laid the groundwork for civil rights litigation and the mass movement that began in the 1950s, what we now know as the freedom struggle. But then the freedom struggle unfolded in a way that hid that groundwork. Second, black people's legal activity helped make law, not just public law, but also private law, such as the law of contract. But lawyers, judges, and law professors, for their own professional reasons, obscured those contributions to private law as well. So what am I talking about? Right from the beginning, civil rights lawyers decided to put the rights of everyday use outside the category of civil rights. So in 1912, the NAACP's legal bureau set up as a general policy that they would turn down, and I'll quote, cases which do not specifically involve the Negro question, but come to you simply because a Negro is involved. So those are now outside the category of civil rights. These are things that the organization will not get involved in. W. Du Bois explained this policy with an example. He said, the legal bureau has received a letter from a widow who is facing foreclosure on her house. The NAACP, he said, cannot help with these purely civil and personal matters of property. It has to save its precious legal resources for cases involving discrimination and injustice because of race or color. Cases that would set precedents for the rights of colored people as a whole. Now, black people kept pestering the NAACP for help on other kinds of cases as well. Murder cases, abusive railroad conductors, and of course, a single mother facing foreclosure on her house. But the NAACP stood firm. As painful as it was, Du Bois wrote, the legal bureau had to rule out these cases of injustice to individuals who happened to be black. Now, of course, the idea was self-reinforcing. Once black rights get defined in terms of anti-discrimination, then almost by definition, cases involving property or contract, or cases that involve other black people, become purely civil or personal. And yet, despite this line drawing, the rights of everyday use wound up becoming crucial to the mass movement that emerged in the 1950s. So, for example, black landowners let out-of-town activists turned their spare bedrooms into offices, turned their farms into meeting grounds. They signed bonds against their farms to bail out activists from jail. The famous 1965 voting rights march from Selma to Montgomery might never have happened if black landowners along Highway 80 had not given the marchers permission to camp on their land. The activists watch in helpless admiration as these black landowners face a blast of economic retaliation. And so the activists try to make sense of what they're seeing. They found their explanation in culture. They figured that some black people were already primed to get involved in the movement because they had grown up in landowning families and relatively protected from white racism and unafraid of it. So, for example, in Madison County, Mississippi, CORE activists, Congress of Racial Equality activists, were awestruck by a man named C.O. Chin. This is someone they described as a restaurateur. He owned a restaurant, he was a landowner, and the activists wrote later, he was locally known in those parts as, quote, the type of person that didn't take shit from anyone, end quote. Over in Holmes County, there was Hartman Turnbow. Hartman Turnbow, in the spring of 1963, he faces down a group of white terrorists who fire at his house. He goes, shouts out, and shoots back. And then he warns the terrorists, and he says to the sheriff and everybody else that anybody he caught on his land after dark was going to get lit up like a Christmas tree. So these are incredibly brave things to do. And the SNCC activists come to believe that it's landowning that has instilled this independence into black landowners. And it's an independence that they think that sharecroppers don't have. Sharecroppers don't have it because, the activists believe, they have the plantation mentality, an ingrained sense of helplessness and dependence on whites. This cultural theory, I think, explained and justified what the activists were doing in the South. Now, to be sure, the activists' views on the matter were complicated. Some SNCC activists actually derided what they called local people-itis. They thought, look, this is just a way to romanticize local people and cover up our own disorganization and chaos. And some SNCC activists actually understood quite well that the local people they were trying to teach about their rights were already quite familiar with legal rules and legal concepts. And yet, many movement activists and writers often interpreted local people's behaviors in nostalgic, almost anti-legalist terms. Again and again, the movement lifted civil rights up from the House porch and the county courthouse into the universal values of freedom and justice and dignity, and then returned them, transfigured, as moral arguments. Now, of course, something got lost in that transfiguration, and that is this long, rich history of black people's legal experiences and ideas about rights. And so I think activists bequeathed to us as scholars three deeply flawed assumptions. First, that common law rights under state law and the local courts that judged those rights had been a closed book to black people before the modern freedom struggle. Second, that those rights were somehow not civil rights. And third, that those rights were essentially irrelevant compared with protection from discrimination or subordination as defined by Congress or the Supreme Court, much less compared to the broader human freedoms that the activists were now seeking. Now, for their part, white legal professionals did not transfigure the black legal experience, they buried it for the most part. So take contract law, for example. This was, I would argue, the formative era of American contract law, and leading law professors, judges, and legal commentaries routinely cited black people's cases as precedents across a wide range of doctrinal areas. And yet they almost never mentioned, by the 1960s, that black people were parties to these suits. In other words, they silently passed them into legal doctrine. Now, stripping out racial facts influenced the legal doctrines that these cases established. It enabled some cases to sweep wider than they otherwise would have. and it hemmed in others, and it shaped how lawyers and judges understood them. Now, legal professionals were perfectly free to do this. The federal laws passed after the Civil War seemed to say that no state could create separate bodies of law for people of different races. But Congress never said that judges had to ignore race. So ever since, I think legal professionals have been making up their own minds, case by case, about when race matters in contracts. Now, in practice, lawyers and judges, I think, tended to invoke race opportunistically, depending on which position seemed likelier to help them win the case. They didn't always cover it up. Sometimes they lifted it up. So, for example, in the slaughterhouse cases, the plaintiffs talked about everything except race. So this is the brief from these ex-Confederate soldiers. They're butchers now. And, their brief, to me, reads like kind of a greatest hits album of the history of oppressed white people. They talk about the ancient Romans, medieval peasants during the reign of King Richard II. And I think the point that they're making is they want to show that Louisiana's slaughterhouse regulation has imposed a kind of slavery onto small businessmen. But Justice Miller's opinion for the majority insisted that the Civil War and the 13th, 14th, and 15th Amendments were all about race. Their one pervading purpose, he said, was the freedom of the slave race, the security of that freedom, and the protection of the newly made free citizens from their former masters. So the slaughterhouse cases showed that lawyers and judges could widen or narrow the scope of a constitutional provision by manipulating the materiality of race. Smart lawyers figured out that they could do the same thing in private law. Consider the 1916 case, Southern Express Company versus Byers. Here, the US Supreme Court barred contract damages for mental anguish as a matter of federal law. So John Byers sues the railroad for failing to deliver a silver gray casket, a robe, gloves, and hose in time to bury his wife, who had died suddenly while visiting her mother in South Carolina. Now, John Byers' lawyer made sure to get it into the record that he was black. You can see the very first question that the lawyer asks basically is, are you a black person? But then when the case reaches the US Supreme Court, Justice James McReynolds erased that fact. Now, McReynolds, of course, is one of the most flamboyantly racist people ever to sit on the court. He turned his chair around to show Charles Hamilton's Houston just how much contempt he had for Houston. He frequently used racist language in other contexts. And yet in Byers, he did not say a single word about race. He hid John Byers' race because he wanted to issue a pro-business holding that would frustrate not just black plaintiffs, but any plaintiff who was seeking contract damages for mental anguish. Justice Miller highlighted race, and Justice McReynolds suppressed it. But I think each justice's choice illustrates how opportunistically race has been treated in law. Now, casebook authors had to make choices too, and their choices were going to be constrained to an extent by what the materials disclose. It's important to remember that many of the cases reprinted or cited today in first-year contracts casebooks were chosen during the decades between the end of slavery and the end of Jim Crow. The cases were chosen, of course, not because they were representative or because they were frequently cited, but because a handful of Ivy League law professors thought that they illustrated certain legal principles neatly. In their editing and their case selection, the casebooks inadvertently muffled the role that black litigants, racial ideas, and the legacy of emancipation had played in the development of contract law. So, for example, the 1972 edition of Fuller and Eisenberg's Basic Contract Law featured several cases involving African Americans. Taft versus Hyatt, which the casebook used to teach offer and acceptance. The person described as, quote, a member of a Masonic lodge was actually a member of a colored Masonic lodge. And that lodge's members were actually trying to protect him from a lynch mob. On page 255, in the section on past consideration, there was Harrington versus Taylor, where the plaintiff sued on an oral promise to pay damages after she had injured her hand saving the defendant from being decapitated by his wife. It turns out that all of the parties in that case were black. And there was Ricketts versus Pennsylvania Railroad, where Judge Jerome Frank used a railroad waiter's attempt to void an accident release as an opportunity for a grand comparison between the will theory and the objective theory. I ordered Sidney Ricketts' pension file from the National Archives, and he was black too. But the students couldn't have known that in 1972, and I think their professors couldn't have known it either. My point is more fundamental than a critique of erasure. It is about the basic process of what Risa Goluboff has called doctrinal distillation. What got reprinted in the casebooks was only the last in a string of decisions about whether and how to talk about race. And these decisions got made at every stage of the legal process by litigants, trial and appellate judges, casebook authors, restatement authors. Similar to the way that some colored people, and I use that term advisedly, were allowed to pass as white, colored cases got passed silently into the heart of contract law when legal professionals elided the fact that a litigant was black, and when they turned slavery into an abstraction detached from race. The result was to make civil rights and contract seem like completely separate categories of law, darkening one, whitening the other, and impoverishing both. And that, in turn, encouraged white students to think of race as something that was tangential to real contract law. Now, whether it was made out of embarrassment or a desire to modernize law teaching, law professors' casebooks and classroom choices wound up in the 1970s treating black students essentially as guests to a white limestone cathedral that had ostensibly been built by white men. And so when those students opened their contracts casebooks, the only case that even hinted that a black person was involved was in the section on unconscionability, Williams versus Walker Thomas Furniture. Now, why does any of this matter? Lots of reasons, but I'm just going to mention, I think, 3 here. The first reason, as I said, is that I think it can help desegregate American law. Contracts and property are not white. They only look that way because law schools treated civil rights as a special minority-focused body of law, veiling what cases brought by black people had contributed to core areas like contract. They look white because law professors and historians implied that black people encountered law meaningfully only in criminal justice, voting, the workplace, schools, and public accommodations. That is to say, in cases about race. The point goes even deeper. Some of contract law's core principles come out of a long struggle over the meaning and limits of market freedom in a post-slavery society. So when Jacob Howard, as I said earlier, called property, contract, and standing the ordinary rights of a free man, he was defining, in fact, the scope and authority of the Civil Rights Act of 1866. He was defining its authority under Congress's 13th Amendment power, Section 2. And he says that a slave was a person who, quote, had no rights, no right to marry, no right to own property, no right to, quote, keep the bread he earned. He was nothing but a chattel. And in this, he is, of course, extending a line of successful argument that Abraham Lincoln had laid down in the 1850s. It's what brought Lincoln into the White House, that these are the fundamental rights of a free man. This is what makes someone a slave. It's that you do not have civil rights. But in fact, slaves across the South had routinely owned property and made bargains that not only looked like contracts, but were called contracts by Frederick Douglass, by Sojourner Truth, and a surprising number of white Southerners. Now, what they lacked, of course, what these bargains lacked, what made them bargains rather than contracts, was that the slaves couldn't sue to enforce them. But in most other regards, white people respected them as part of the common sense of law. And so what that means is that ironically, in redefining civil rights as the rights that mark someone as not a slave, the Republicans of the 1860s crowned a long-term shift in law and political discourse that made it unthinkable that a slave could ever have owned property or made contracts. Bill Nelson memorably calls this shift the jurisprudence of anti-slavery, and it deeply informed the development of core concepts of capacity, voluntariness, and coercion during the formative era of American contract law. Second, once we see how long legal professionals have been grappling with when and how to recognize race, I think that the perceived choice between race-conscious and colorblind approaches to law starts to look like a false dichotomy. So today, Jim Crow is gone, arguably, but one could argue that the Roberts Court is continuing the old pattern of opportunism. So the Roberts Court insists that government recognition of race is equivalent to discriminating on the basis of race. And yet, as my colleague Chiara Bridges has shown, the court's conservatives do frequently talk about race, equating abortion with genocide, claiming the 14th Amendment was enacted partly to ensure that freed people could arm themselves against the Klan, and in affirmative action jurisprudence, often dwelling on the feelings of disappointed white applicants. The scope and stakes of racial opportunism are only growing now that the Trump administration is redirecting federal agencies to investigate discrimination against white people, for instance, and prioritizing Afrikaners for refugee resettlement. Once we stop pretending and frankly acknowledge the fact that legal actors are always making choices about whether to recognize race, I think we can think more productively about how and why we're doing it. Now, finally, I think that this story of Black legal lives can help put African Americans' relations with each other at the center of African American history in all of its rich messiness. So today, it's axiomatic to say that Black people have fought for independence in their working lives, autonomy for their family and communities, and equal citizenship in the body politic. But what did autonomy mean to Nate Shaw, who said that his own father treated him just like slavery? What did equal citizenship mean to Black women who were treated as second-class citizens in their churches and their fraternal orders? The story of African American history is, in no small part, about how Black people struggled with one another about what a Black family is, what a Black corporation is, what a Black community is, and what its members owe to each other. These struggles are barely visible through the veil of race relations, but they gleam from cases that were not primarily about race: inheritance, partition, contract, divorce, and more. And they beckon us, I think, to see Black history as something more than echoes of America's original sin, or signposts on the road to a more perfect union, or a struggle for freedom. My basic premise is that Black people's lives are worth studying in themselves. Thank you. And unless I talked too slowly and ran out of time, would love to take questions. I'm still learning.
We have about 15 minutes.
Just raise your hand. We have 2 mics.
I'm going to take this moment to grab a pencil. There we go.
So, good afternoon. Yes, thank you so much. So I see several of my property students are in here. So I imagine that a lot of this information resonates with some things that we've discussed. So could you even just sort of as a bare bones, talk to us about the experience of looking for those land records and sort of how that process maybe shaped your research project? And so I know you talked about the limitations of how you selected cases, but could you just walk us through? Because I don't think they have full appreciation for what one of those record rooms even look like. Yeah.
I mean, I guess there are two ways of answering that question. One is to talk about the experience in the local courthouses, and then another way is just sort of the more standard research tools of using Westlaw, right? You know, when it comes to looking up cases involving black people using Westlaw, you know, there are certain techniques that one can use. You can type in keywords. Some of the keywords, unfortunately, have to involve racial epithets because that's sometimes the only reference that you see to African Americans in them. But then again, I think it's also a story, this history of legal thought. What I was getting at with the reference to Jacob Howard is essentially the roots of Lochnerism. You know, we think now like the Roberts Court, some people argue it's inaugurating a new era of Lochnerism, neo-Lochnerism. Well, if you want to think about what is Lochnerism, I think, you know, one way to think about it is that it is the jurisprudence of anti-slavery. It's these judges who come out of these Midwestern states like Ohio, Pennsylvania, Illinois, and you know, they go on to positions of power, and some of them ascend to the Supreme Court, and they bring with them this basic idea that the slave is the polar opposite of a free man, and they enshrine that into cases like Lochner. So that's one way to think about it. The other way, as I said, is, you know, thinking about these, you know, these records rooms. I think, you know, the experience that I had, very quickly I realized that, you know, the people who run the circuit clerk's offices, it is not an archive. Like, they're not there to serve someone like me. And so I had to go in with a different mindset. Obviously, whether you're dealing with archivists or circuit clerks, you know, it pays to be polite, pays to be nice. And you have to build up a little bit of a relationship. Like I said, for the most part, since I was asking for old records, they kind of didn't really care that much as long as I didn't get in the way. Now, once I got in the back, you know, I said earlier that the civil court records were not segregated. I would also add that the land records were not segregated either. And so if you're looking up deeds, which is what most of the people I was sitting elbow to elbow with were doing, they were doing title searches, you won't find racial markers in the deed books either. But over here on the shelf for marriage records, right, so the divorces, they're civil cases, no race marker. Marriage records, they are marked by race. Why is one marked, not the other? I think it's because race it has a legal meaning in marriage records that it does not in divorce records or in land records. So there's sort of a function that most of these states have laws against interracial marriage, and so you have to know who's black and who's white in order to marry people. But in terms of just the experience of getting into these courthouses, you know, I think those are sort of some of the basic preconceptions that I had to kind of get through. It's not an archive. These records are not marked by race. But nevertheless, you actually can find a rich history of African Americans in those records. They're doing stuff.
I was wondering if you saw any constriction in civil rights as they began to perhaps challenge white hierarchy. You know, I'm thinking of Mike Klarman's work about how Southern police forces were being integrated, and then after Brown, it's like, no, none of that. Everybody took 2 steps to the right. So I'm wondering if you saw any of that as the rights became stronger. Was there pushback? And just curious.
It's a great question. The way that I have come to understand what's going on here is that civil rights gets redefined over the period and narrowed in a way that enables someone like James Eastland to continue taking on clients who are seeking tort damages, right? Like, I look at James, he's this segregationist senator from Mississippi, and he keeps Civil Rights Act bottled up in committee for like 10, 15 years. I looked at his papers, and he's got black clients peppered all through them. But they're not suing for civil rights as it is understood in 1964, right? They're suing for civil rights as Abraham Lincoln understood it, but by 1964, the category, the term civil rights has come to mean discrimination on the basis of race. Eastland's not taking that kind of case, but he is perfectly happy to take a case, damages against the electric company, if it's going to make him $1. And in fact, white lawyers throughout the period, they are overwhelmingly the people who represent black clients. They want the business. They kind of fight each other for the business. And one of the reasons there are no black lawyers in the South after about 1890, I think, is because white lawyers wanted to take over the business that black people were bringing to court. So, there is this kind of backlash as the marches get going, but it doesn't land on the civil rights that I see in the courthouses because it's not understood as being civil rights anymore. It's just a contracts case. It's just a tort case. Does that make sense? Yeah.
Let's see if I can properly explain this question. So you mentioned that during the pre-1900s, that basically they were being able to remove people's abilities to go to court, and necessarily it kind of erased people from records and their struggles. Would you see that the current government's attempts to police courtrooms and courthouses themselves, would that also be a form of returning to that pre-1900s era? And if so, would you follow the same attack pattern as they did during the civil rights movements from that point to the 1960s, or would you recommend a different approach?
No, it's a great question. I mean, the thing that's running through my mind as I think about how to answer your question, and it's related to the one I just answered, is that so much depends on how people understand the type of controversy that's before the court. During the 1900s, there is this pattern of opportunism in private law and public law. Again, I don't necessarily think it's solely about erasure because sometimes they're lifting up race. And so to draw a parallel or a connection to the removal of people of color from courtrooms today, it seems to me that there's some kind of connection, but I'm not quite sure that it's not a direct connection. And I think that the thing that I want to emphasize more is that it's not solely about erasure. That depending on the type of case that we have in front of us, and depending on the goals of the particular legal professional, that person may want to emphasize race. And they may want to do it either explicitly, like saying this is a black person, or implicitly, like in Williams versus Walker Thomas, where they famously never actually say that Orley Williams is black. And you can find a number of cases like that. But they're sort of laying little signals in there that people at the time understand. People understand in Ricketts, even though he's not flagged as a black person, there are so many other markers in the case that allow readers of the case in the 1940s to understand, oh yes, this is a black person. He's in fact the paradigmatic black person and is useful because of his helplessness. He's the paradigmatic helpless person. So I guess that's sort of my rough and ready answer to your question. I can't draw a direct connection, but I think there may be something there.
Any last questions? Ethan. Oh, we got, who, was it Hank?
Ethan and then Hank.
Well, I probably can't do both.
Okay.
Because we've got 3 minutes.
Battle of the questions.
I can talk quick, maybe.
Okay, well, let's go with...
Thanks. I was curious as to whether you could talk about how you might define race and how it may have been defined over the time period. For example, the distinction between a one-drop rule versus a blood quantum rule, and whether that might have had an effect on how people were classed or raced in particular cases.
Yeah, no. So I'm thinking of like a massive historiography in U.S. history that is about the changing ways in which Southern and Northern courts defined race over 4 centuries, right? There's this one-drop rule. And then I'm thinking about the ways that these courts actually wind up recognizing or not recognizing race. I mean, in a sense, I suppose that sometimes the one-drop rule is what they use, right? Like if there's any sort of racial quantum present in the plaintiff or the respondent, then we're going to recognize it. But in other regards, I think sometimes they disrecognize it. That the metaphor that I use of passing, it is a metaphor that I'm taking from sort of human people and trying to show that it has application to the ways that judges deployed or did not deploy race. Passing is, of course, about a very light-skinned African-American woman, that novel by Nella Larson, who, is able to pass and sometimes gets involuntarily passed. Like there are times when she doesn't want to be passed. I don't want to spoil the plot of the book, but what finally, the tragedy occurs at a moment when she is standing next to people who are seen as phenotypically more African American. And in that moment, there's this flash of recognition that enables her to be recognized as black. And so I think you can sometimes see, again, this pattern going on in cases where just by juxtaposing one case next to another case or a string of other cases, casebook authors will sometimes flag very implicitly, oh, this is a case involving race. But in terms of whether the litigants themselves were being recognized as African Americans, I suspect that in terms of sort of how they looked on the spot would have mattered perhaps less than local people's knowledge about who they were. Because after all, they're going to these local courthouses. Many of them are in rural areas, and they're well known, who their race is. And I think some of that is going on in my family as well, that people can sort of tell. But again, going back to the first question about going to the courthouses, one of the things that I understood going in was just my positionality, looking how I look, an African American, very light skin. I'm also a man. And, all of those things mattered, I knew, silently, as I walked into the courthouse and introduced myself to the courthouse clerk. Not necessarily in a good way or a bad way, just something that I had to be aware of. So I guess that's my answer to the definition of race that's at work in my book. It's happening on multiple levels, including the researcher's experiential level. Thank you.
This has been absolutely terrific. Please join me in thanking Dylan Penningroth for sharing his work with us.